Hello, everybody. My name is Ryan Calo. I am a law professor at the University of Washington, and I'm also a faculty co-director of the Tech Policy Lab. And in partnership with Microsoft, we have an amazing conversation with some guests today over the next hour to talk about the question of privacy redress. And so I'll introduce them in just a moment, but I know you know who they are. But I first wanted to say a couple words about why this is so important. This is the question of if someone's privacy is violated, right? How can they get redress for it? It's one thing to say, hey, you have privacy, it's a right that you have. Look, this entity over here is violating your privacy. But what's your recourse? How do we give privacy teeth? And that is an incredibly important question right now because of the political will to actually address some of the problems that have been extant in the United States and abroad for a long time now. And so we've convened this public conversation just to have some experts, some folks who have a current front seat to the debates in this area. Okay, so. I'm going to start to introduce them, and I'm going to ask them to say hello to us. So the first person I wanted to introduce is Noah Phillips, who is a commissioner at the Federal Trade Commission. Commissioner Phillips, we're so glad to have you here. Can you say hello?
Hi, Ryan. Thanks for having me. It's great to be here with you and with this incredible group of people that you've assembled.
Great. Well, we're really honored and excited to have you. And next up, I want to introduce Terrell McSweeney, who is a former Commissioner of the Federal Trade Commission, and presently a partner in the privacy practice at Covington and Burling, where Terrell was just talking about this. I actually started my career at Covington, so I have a special place in my heart for that great firm. But if you could say hello to everybody, I'd appreciate it.
Yeah, pleasure to be with you today, and I'm really looking forward to our conversation. Thanks for having me.
Great. Next up, I have Professor Lauren Schultz. She is the McConaughey and Risman Professor of Law at the Florida State University College of Law. And she is she's a leading privacy academic and one of the few privacy academics to have actually written specifically on the question of remedies. And in particular, we're very excited to have you here, Professor Schultz. Could you please say hi to everybody?
Hi, everyone. It's really great to be here, and I'm so excited about this discussion.
Awesome. And last but definitely not least, Julie Brill. And Julie is also a former Federal Trade Commissioner and someone I've known a long time and worked with a long time, but is presently the Corporate Vice President, Deputy General Counsel, and Chief Privacy Officer at Microsoft. And so Commissioner Brill, or former Commissioner Brill, Julie Brill, could you please say hello to everybody and introduce yourself?
Of course. Well, thank you. Thanks so much to you, Ryan, for hosting, and especially thank you to the University of Washington for helping put on this really important event and having the conversation about this incredibly important issue. So it's great to see everybody.
Yeah, no, seriously, I really appreciate everybody's time. And this is a challenging time for everybody right now, right before the holidays and everything. But there almost couldn't be a more critical time to address this set of issues. All right, so Julie, I'm going to jump right in and just ask you a question right off the bat here, which is that I alluded to how this is, a key issue of our time. But why is redress, this question of privacy redress, so important to such an important piece of the puzzle when it comes to having, say, a federal privacy law?
Sure. So, if you view privacy as a fundamental right, as I do and as Microsoft does, and if you believe that people own their data, then you start to think about the fact that people need to be able to control their data if it's theirs, and they need to have some kind of redress if their ability to control their data is, they don't have it for whatever reason. A company doesn't give it to them, or they're just unable to speak to a company about how to get the kind of control over their data that would be spelled out in any kind of privacy law. So, there are some very robust proposals on both sides of the aisle in Congress right now to give individuals control over their data. We think that that's incredibly important. Before those laws are ever passed in the United States, we at Microsoft already provide those kinds of control rights to individuals, and we see literally millions and millions of people come to our dashboard to exercise those rights. But if for some reason a consumer can't, the company doesn't delete their data or doesn't give them access to their data or doesn't help them correct their data if there's a problem with it, then individuals need to be able to get some kind of redress for that individual problem. I really think that any kind of federal privacy law that we may see, and hopefully we will see very soon, is going to have strong enforcement by the FTC, by state attorneys general, both of which are going to be very important in order to ensure that the strong provisions of a law are followed by industry. But there are still going to be issues that are really individual issues like, hey, I can't access my data. Hey, this piece of data was supposed to be deleted and it wasn't, right? Those are the kinds of individual issues that we think, people, they absolutely need to be resolved, and people need to have a roadway, a pathway for resolving those kinds of issues. It's going to be critical to think about this as we move forward with privacy legislation. This issue around redress has been one of the major conversation points. And so I'm really appreciating the conversation we're having today to try to think creatively about how we can bridge gaps between the various stakeholders and how we can move forward with some really strong legislation, including some form of redress.
Great. So, Noah, by the way, I'm going to remind our panelists, unmute yourself if before speaking, and then afterwards, be probably important to mute yourself after that, so we don't get any other noise. But no, I'm going to turn over to you. So, I've seen some of the draft legislation. I've been party to some of the conversations right here. It seems to me like almost universally everybody sees a role for the Federal Trade Commission, right? Of course, which you're a sitting commissioner. Is the Federal Trade Commission the right authority to enforce federal privacy in the United States? I mean, do we want it to be the Federal Trade Commission? Do we want it to be a new agency? Who should be doing this enforcing in your view?
So with the caveat that I always have to give, that my opinion is mine and not necessarily reflective of my colleagues with the commission, what I can tell you is that we all agree it ought to be the Federal Trade Commission. The reason for that, to me, is pretty self-evident. And that is the FTC has been doing privacy and increasing what it has been doing on privacy, thanks, in part to the leadership of two of the folks on here, Terrell and Julie, since 1970. And there's a lot of built up capacity. There's a lot of understanding of the legal issues that surround privacy, the economics of privacy, a lot of thinking that's been done in-house on harms. So I think without a doubt, we're the right place to do it. What I'd add to that is the fact that even though we don't have a general consumer data privacy law in the United States, something I was saying just yesterday in a Senate Commerce Committee hearing is that if you think about it in terms of enforcement and the success of remedies and the success, whether they be equitable or monetary or what have you, I think the FTC remains today the leader in privacy enforcement worldwide. I don't think there is any agency, even armed with GDPR, that has had more of an effect than the FTC has. And I think it would be a pity to lose all of that really important institutional knowledge and capability moving forward. So I think we're absolutely the right place to put that authority.
Can I follow up on that? I mean, that's interesting. In the scholarly community, there's a lot of discussion about sort of who's having the most influence, on privacy. And some say it's Federal Trade Commission, others say it's Europe, and there's this thing called the Brussels effect, where we're all just, and yet others are saying actually you'd be surprised how influential the state attorneys general are, right? And so that's an interesting and good claim for people to hear, that the Federal Trade Commission is making a claim that it is a leading authority in this area. One question I do have as a follow-up, if I may, Noah, is do you have enough resources to do this? I mean, today, do you feel like you have enough resources in terms of personnel and budget and so on because it's kind of a big task. I mean,
it's a huge task. It's a huge task. And the first answer is no, we don't have enough resources. The second answer is that if we have a new federal privacy law, we're going to need a lot more resources because it's a tremendous undertaking. So I don't think we have the resources to do it, but we do have the know-how. And to be clear, part of what I'm talking about is obviously in Europe, you've got GDPR and you've got DPAs all around. My point is from an enforcement perspective, that I think we've really had more of an impact than anyone. Having a big law, of course, that has a really important effect in instructing companies on what they, can do, can't do. It has other effects too that maybe we can talk about. But I think in terms of enforcement, cases brought, outcomes achieved. That's where I think we're doing really well. But to answer your question, if we're enforcing a new federal privacy law, you bet we need more resources to do that.
Got it. Tyrell, I'm going to turn to you now. And so we heard Julie a moment ago sort of allude to the both sides of the aisle are interested in this topic, right? But presumably there's not complete agreement, I would imagine, between different parts of our legislature, of our federal legislature. And so one question I have for you as a person who has been an FTC commissioner, is now in private practice, and still an ongoing active participant in this dialogue, is do you think there's a compromise we are going to be able to reach here? I mean, is there a compromise that can adequately protect consumer privacy but still satisfy whatever other interests might be pushing back?
Well, I certainly hope so. I'm an optimist by nature, and so I prefer to see all of the progress that's been made over the last several years iterating on this topic and coming to some actually pretty broad zones of agreement that didn't even exist 2 and 4 years ago. So I think the dialogue has shifted dramatically towards very broad areas of agreement that make me hopeful that we'll be able to get there with strong legislation. Some of them we've already talked about. Obviously, a big one being who's enforcing, seeing a role for both state AGs and the FTC, potentially rulemaking authority for the FTC, resources for the FTC. And I'm really glad to hear everybody kind of call that out as a necessary issue, as I think it's a significant one. I mean, obviously, there's still some very tricky questions here, and we're talking about one of them. How individuals' rights are protected and vindicated is, I think, an area we're really going to need to see some constructive and collaborative work on. In my view, there's some interesting ideas out there. I guess I should have started with the disclaimer that these are my individual views and not reflective of any client or the law firm. But we've seen different proposals from advocacy organizations with a right to protect individuals, to safe harbor compromises coming from others. So I think that there is active discussion. I think another area of potential compromise in some of these tricky areas is to think about what kind of violations an individual right would be really applicable for, and what kind of relief would be the right kind of relief, which I know is the topic of this conversation, which is why it's so timely.
Yeah, so I'm going to follow up because in a bit I want to ask everybody what their views are specifically about a private cause of action, where what is meant by that is individuals being able to sue, the sort of David v. Goliath kind of idea of that, right? But you alluded briefly to something called a safe harbor. And for anybody who's tuning in who doesn't think that maybe a bit of a term of art, what is a safe harbor, and what kind of role would you envision that playing? Like, what does that mean?
Sure. Well, a safe harbor is a term of art, but we use safe harbors in all kinds of different ways, in different frameworks. And essentially, it is a way in which a company can comply and have some assurances that it is in compliance with a regulatory framework, and then have some ability by enforcers to verify that compliance. So obviously, we see this as an option that's put forward in some other frameworks, and so I think it's interesting that it's come up here. There is obviously very healthy debate about the efficacy of that kind of a solution, and whether it really properly protects individual rights. So I'm not putting it forward as a total solution by any means, but I think it's interesting if we're trying to think about pathways to compromise, that it's certainly a proposal that's on the table.
So the idea of a safe harbor then would be that if somebody complies in a way that they can, if a company, for example, complies in a way that they can verify to the right people, right? It would then protect them from, what would it protect them from? Would it protect them from the Federal Trade Commission, or from individual litigants, or from just whomever? Or could we vary that? Is that possible to change around?
Yeah, I mean, and I invite others on the panel to jump in here as well. We haven't heard from Lauren yet. I want to bring her in. The answer is, I mean, I think you can structure a safe harbor relatively flexibly. It depends on how it's designed, but certainly it could be used as a way to sort of mitigate against enforcement. The FTC generally, I mean, that's not going to be effective unless there's some way to sort of audit the compliance with the framework, right? But yeah, you can use it in any of those ways.
So I'm about to go to Lauren to ask a little bit about her research and to pivot our conversation towards ideas of like what the harm is and how we redress it. But before I do that, I do want to offer Noah or Julie, do you have anything else you want to add specifically about safe harbors? That's one of the things I found, that a lot of times people who are relatively new to the privacy discussion, it's a kind of a term of art to them, and so they don't quite know what to expect from it. Anybody else wanted to add to that, or no?
I'm happy to add just the following thought. I mean, I think there's something really important to consider as we think about this scheme. I will say that for me, safe harbors, in a sense, are a tertiary issue. So, and redress is a secondary issue. To me, the first question is, what are the set of rights that we're enforcing? And around that, you want to build a set of remedies, right, including the redress that people may have. And then think about safe harbors as a way to sort of ameliorate, soften the blow, or more importantly, guide companies in the right direction. And I think all of these things are part of a package, if that's helpful.
And I'll just say very, very quickly, this is Julie, that I like the way that Noah just laid out that three-part sort of framework for thinking about safe harbors. The one thing that I think safe harbors can do is, if it's a really robust framework, a robust safe harbor that has been approved by the regulatory agency, as under the Children's Online Privacy Protection Act, happens by the FTC, then the safe harbor program can help companies make sure that they are complying. And that's sort of at its best. A safe harbor program can serve to work with companies to bring them into compliance, to bring out best practices, help them understand what other companies are doing so that they can meet the requirements of the law. That's at their best. And if that's what we aspire to in a safe harbor program, then I think it can be very helpful for the entire ecosystem, consumers, as well as companies that are just learning about what privacy laws, and especially robust privacy laws with the strong standards that Noah mentioned, might require.
So thank you very much. That's really helpful. Again, just to explain to folks what that tool is and what it might mean. So the way that I personally got into privacy and some of the early stuff I wrote myself was about the nature of privacy harm. And what's been kind of interesting over the years has been to watch us move from a place where we were uncertain what constitutes privacy harm, maybe even uncertain if there was privacy harm, was that really a thing, to a place where now we recognize that there is privacy harm, and the question has become, how do we address it? But Lauren, I got to say that you really this is now an issue that's much discussed, and maybe even federal privacy legislation might turn on this question, right? But you were writing about this years ago and got interested in this years ago. So as a scholar in privacy, what drew you to writing about redress initially?
I started writing about redress at a time when, as Ryan was saying, people were thinking that the main problem, let's say, preventing a vindication of a privacy right was some lack of agreement on what privacy was or whether or not privacy was worth protecting. Whereas I saw, and what drew me to this question was something of a more actuarial question, right? So we see a lot of courts ruling that privacy plaintiffs don't have standing, so we don't get to the question of what privacy is or whether this particular right deserves protecting because of this standing problem. And Ryan has said as well, he's written on this issue, he wrote specifically about this privacy harm exceptionalism. So it's not even just dignitary rights or anti-consumer sentiment generally. Courts seem to have had a particular worry about finding standing for privacy plaintiffs in particular. And I started to think, and this is something that's plagued privacy actually since the privacy torts were first formalized and became adopted by many courts throughout the country, is that there's this worry that if there is a right to privacy at law that anyone can avail of, that we could end up with very, very high and unfair and uncertain awards to plaintiffs. And that's really what's motivating, in some ways, this fear of actually getting to the merits, right? So we can say, well, maybe the harms are too speculative. So I thought that was this kind of hypothesis, because there was this whole problem of, okay, how do we get to the point that courts will recognize that there is a concrete harm in the area of privacy when they seem to be using this higher standard? And I think this goes into a broader conversation as to why everyone's at this table in the first place, is if we could manage and make more predictable what happens when someone shows that there's been a privacy violation, we might be able to get courts and legislatures and everyone a little bit less scared about what would happen if, let's say, we say there is a consumer comes into court or wherever else and vindicates a right. So if we can get those rights more certain, if we can figure out what the consumer gets in a more certain way, we might get to a point, paradoxically, where people are less worried about standing. So I was really, I guess that's sort of what got me to this point, because it's kind of this pragmatist thing underlying what was formerly a conversation about, but what is privacy anyway? When is there standing? I started to think what people are really worried about is what happens when we have to pay up. How much will we really have to pay? And
oh, go ahead. Sorry, I was just saying I'm seeing some vigorous nodding by the other panelists, and I was gonna, but go ahead. I didn't want to cut you off.
No, go on. I want to hear what they had to say. I noticed it too.
No, but that's fascinating. So I see some vigorous nodding over there, and I want to make sure Noah, Terrell in particular, you get the chance to weigh in on that. And I'll come back to Lauren.
Sure. The first thing I'd start with is my compliments to Lauren for the really rigorous legal realist approach to this question, which is, why are courts doing things like making standing decisions? They're doing it because they see a problem that they're not sure they want to handle, right? They're tossing the case. So I think that's a really important insight. To me, it also tracks with a very real political dynamic going on. All of us know that if you look at a lot of the different drafts, at least, of legislation, the big differences aren't in my first bucket of what your rights are. You can probably build consensus on that very quickly. The hang-up is on whether it's private right or state AG enforcement, fines. That's where the hangups are. And it's because there are these fears. And to be clear, I think they are legitimate. And I have some thoughts about how to think about these issues. But the fear, like the courts are fearing, that, you've got these wrongs, right? These violations of whatever they are that are so numerous that we're going to be dealing with fines that are just stratospheric in the conventional understanding of American, Anglo-American tort law. So we're going to avoid it. And by the same token, in Congress, a lot of people are looking around being like, whoa, it is very easy to count to 1 million violations. So if I'm at $5,000 per violation and there are 1 million violations, I just hit $5 billion and my company has 30 employees. And so I think that it is critical to recognize, as Lauren does, and as she has showed, the reality that courts are thinking about, and it maps perfectly what I think is the big hang-up on Capitol Hill.
So Terrell and Julie, I want to also invite you in. I'm going to come back to Lauren in a moment. But Terrell, you were also, I'm outing you as also vigorously nodding in response to those comments. So did you want to add anything?
Yeah, well, I was vigorously nodding, so thanks for calling me out on that. And I think Lauren and Commissioner Phillips have really sort of put their finger on it, right? Which is the real struggle here is trying to assess the scope of the harm and the value to attach to it, and that this is a very difficult thing. It's something that we've been wrestling with in privacy for a very long time. I think there is more consensus maybe than we're giving credit to both the rights and the enforcement, as has been noted already, but also the idea that there has to be some penalty or fine associated with violations. That I see as a real zone of agreement. Again, how we think about individual rights in this context is where there's less agreement, in my view.
Julie, if you want to weigh in, do, and otherwise I have a follow-up question for Lauren.
Well, there's always so much to say. I'll just add one quick thing, because I think we are all in violent agreement here about the framing that Lauren has so helpfully provided. I think the fear that Lauren and Noah are describing is real. And I think it comes from the recognition, in addition to the things that Lauren has mentioned, it also comes from the recognition that we will, if a federal privacy law is enacted, have literally millions and millions of companies be subject to robust, and it should be, robust requirements about how they collect, use, and share data for the first time, and giving users control over their data. And this is not like what has been going on in Europe, where people do point to the European rules, but those have been in place for a couple of decades or more. Doesn't mean that that people aren't still getting used to them, still acclimating themselves to it. But I think beginning right off the bat with not only a robust regime that will have strong enforcement. I agree with Terrell. There is consensus that there needs to be strong federal enforcement. I think there's also consensus about state AG enforcement. I think there's consensus about penalty authority for those entities at the federal and state level. So adding to that the ability of individuals to suddenly bring in these very large class actions, I think that is the fear that Noah is pointing out. And I do think that that is real and has unfortunately become sort of one of those bridges that we're going to need to really discuss if we're ever going to get a strong, comprehensive federal privacy law.
So we may come back to this theme. I did want to ask a follow-up question to Lauren before moving on to it, though, which is that so you ultimately came down on the view that restitution was the kind of way to address privacy harms. That like there was this role for restitution. So my question for you is basically like what attracted you to restitution as an area of law that would be helpful in framing these harm questions?
So there are multiple reasons why I came to that conclusion. Well, earlier I talked about why I came to the question of remedies at all. So I started doing my research and started to understand more and more about these different options. I'm a private law lawyer to begin with, but even if you study contracts and torts in general, as I do, remedies tends to be off on its own. We tend to focus on rights more. So it was an interesting inquiry for me to educate myself in this area of law as well. So when we talk about the end of a case, we normally talk about compensation, which is you were hurt in a certain way, so here's what you need in terms of money or in terms of an injunction for you to be made whole. The law of restitution, which is also just as old and has always been around and is a big part of contract law. That's probably the only time, if any of you guys lawyers, you ever heard about it. It's one of the possible ways that you can receive remedies at the end of if a contract has been breached. And the law of restitution is the law of gains-based recovery. So instead of measuring what is received by the successful plaintiff by the losses to the plaintiff or by what she lost in reliance on the statements or the actions of the defendant, this is measured by what the defendant gained. And the measurement of restitution is not necessarily always larger than compensation or other measures. But in the area of a lot of consumer privacy harms, we can imagine that in a lot of cases, the dollar value of the harm to the consumer, however you frame it, is probably smaller than the benefit of, let's say, a database divided by the number of units in there. If that's a useful way of thinking about it, it is anyone's guess. So I was interested in this for two reasons. One is pragmatic, right? It gets you around standing problems. So as we said, the standing problems are not actually there because there's a real problem in showing what the harm is. I think a lot of people have very ably shown technically there is a cognizable and concrete harm from privacy harms, but this actually just as a procedural and technical matter does get around standing problems because you should be able to broadly make the statement that, well, why was this, company using my data in this way? It's to make them some money. If a business is trafficking in personal data in some form, some money's at stake. So this actually weaponizes what some people call sort of like the anti-human, like humans are less advantaged when getting standing than companies because companies by their very nature tend to seek a profit motive. But if you frame privacy harms in terms of benefit to the company, as opposed to at least the remedy sought, you get around that. So it actually does get around that standing problem technically. But there's a deeper reason. And I do think what it does is it forces a conversation. And I have a lot to say about that, and I'll do that later, because I do think a lot of the problems we're seeing now, like we're now at a moment where, hey, maybe we can pass something, but there's so much that's uncertain, and we're only now getting people at the table kind of admitting that, hey, maybe we can do something here. But what we don't have is 20 to 25 years of case law of courts actually grappling with these issues, because the courts are kicking the can down the road, and a whole bunch of contract language and anti-class action legislation is making it so that the courts don't actually we're losing the public resource of decisional law in this area. But anyway, going back to the other reason why I like restitution is it goes with our intuitions a bit more than a compensation here. Because ultimately, to use the old phrase, if you're not paying for resource, you're the product, right? So let's say if I use Facebook or if I use any resource, you might say, this is sort of a colloquialism, you might say you're the product. I have some problem with it, but let's go with that institution. Let's say that's an intuition. But what happens if someone's using your data and you've already paid for it, but yet they're using your data? Or even more so, and this is the classic, this is what the fact pattern I talk about in my paper. What if they're not giving you any resource at all? What if you've never been in contact with this entity, and yet they're using your information to make money? So the intuition here is perhaps there's something wrong with some business making a bunch of money off of your data and you're not actually benefiting from that in any way. So this is restitution is also called unjust enrichment. So I like bringing restitution into the conversation about privacy remedies simply because I think it does get to a certain intuition when we talk about what's happening in the market for consumer information. And it also, as a formal matter, forces us to get to the point because it gets around the sort of standing conceit that allows courts to avoid talking about the real issues.
Got it. Noah, did you want to jump in?
If I can get my mute button off.
Yeah. I have a follow-up. Go ahead.
So let me start with the following. I do think that it's interesting to think right now, right, what we deal with are really harm and disgorgement or restitution. Right? Those are the concepts at least available to us, pending resolution in the Supreme Court in weeks, or argument in the Supreme Court in weeks on what the word injunction means. But those are the concepts that we sort of handle at FTC day to day, whereas on COPPA, for instance, you live in a penalty regime. And I think even as Congress thinks about how to penalize, it's really important to remember, right, what those other monetary relief mechanisms are, what justifies them, what are their costs, and what are their benefits. One thing that I always think about is, what does the mechanism deter, right? And I think as we talk about leaving aside the penalty frame, the penalty just deters whatever the conduct. One of the interesting distinctions, at least as I see it, between, call it harm tort-based compensation, although sometimes in tort you can get restitution, and restitution is the first will tend to deter more conduct that is more harmful, right? You pay more if you endanger people more, whereas restitution may also deter conduct that is less harmful, but also very profitable. And there may be sort of a social gain in there. And I do think it's important. It's great to talk about these concepts in depth with a real understanding for how they line up with money. Lauren is 100% right. Not always, but usually I think when it comes to privacy, restitution is going to be greater. I do think, however, we shouldn't lose sight of the harm side and the benefits there.
So that's fascinating. So and by the way, what a privilege to be able to host an interaction between scholars and commissioners and so on in this kind of a forum is great. I want to ask a follow-up question, because what this all reminds me of is the idea that when a consumer goes to a court or goes to an agency or goes to their state, and they say, I've been harmed, right? They may be looking for money. Right? But they also may be looking for something else. That is to say, they might want this harm to stop. Or they might just want someone to tell them that they're right, and feel like their dignity is respected, And so I wonder if I could go around, maybe starting with Julie and then Terrell, and we'll go around. But just, is it all about money? I mean, is when a person says they want privacy redress, are they really just asking for more money? And is that always the right way forward? And what do you think?
It's a great question, and I agree with you. It's really a privilege to be part of this fascinating conversation. In my, almost 3 decades doing enforcement work, not just in privacy, but also consumer protection and competition, I have found that mostly what people want is to have bad practices stopped. And it's a dignity issue, and it's also just like, hey, just get them to stop. And sometimes what that means is, I paid money and I didn't get what I wanted, and so I want my money back. I want a refund. I want restitution. But sometimes it is really just like, as you said, Ryan, like let's get this practice to stop. And when I think about some of the most powerful cases that I have been a part of, or that I've participated in, either as a commissioner or a state assistant attorney general or deputy attorney general, really some of the most powerful cases that I've seen have focused on that kind of injunctive relief, saying, yes, there will be a monetary penalty. Yes, restitution is required to consumers, but the company has to change its practices. And that will sometimes happen in a competition realm where you talk about, you can't merge, or we're going to put in place behavioral changes. But it can also happen in privacy cases. And when I think about what individuals want, and I also think about what's most effective, it's sometimes looking at the most harmful practices and saying, these have to stop and you're going to have to change. And because these practices do violate the law, and we worry they will continue to violate the law going forward.
Yeah, I mean, the other thing too is the intuition that I sometimes hear in other contexts is, sometimes people feel like they'll pay a fine or they'll pay out money, right? And they'll just keep doing what they're doing because it's more profitable to them whereas with an injunction, like the law comes in and says you have to stop. And I think that's also interesting and not.
I wouldn't. I wouldn't belittle entirely the power of strong fines, and I do think it's important for the regulators to have that in their quiver to be able to pull out. But I think that power ought to be accompanied by strong injunctive relief. And again, back to your question, what do individuals really want? Some do want money, some want money back, some want some kind of recognition. But I think typically they want bad practices to stop.
So Lauren wants to jump in. Go ahead, please. But you're muted, Lauren. Let me see if I can unmute you. We can't hear you, Lauren.
Sorry about that. I agree with what Julie was saying, and I wanted to add a little bit to it. I mean, what people tend to want is for practices to stop in a lot of cases, although not always, right? But big fines are very, very powerful, and I don't think that they can sometimes get to the conclusions that injunctive relief can get to almost in more effective ways in certain senses. So privacy violations, you want to talk about those. So Gawker was effectively shut down by high monetary damages in several privacy cases. And what availability of high damages does for certain practices might make practices prohibitively expensive, and doesn't just stop one company from doing it. It might sort of deter any company from doing certain things and limit practices, let's say companies that can afford it, which has good and bad outcomes, right? I mean, one of the things that we talk about sometimes is what effects of these privacy laws on smaller companies, because perhaps Microsoft can afford to do any number of things to protect the privacy of their consumers, but when maybe a company that's just an emerging company, it might be too expensive. But I mean, the question is, do we want to have these practices to be uniform or not? But basically, I just wanted to speak up for high fines or high damages because I think they can get to similar conclusions as injunctions, making certain practices too expensive.
I'd love to jump in on this too, Ryan, if you'll let me, because I agree with both points, and I didn't understand Julie to be saying there was no role for penalties or fines at all, but because I would certainly agree that the other part of the overall calculation around the effectiveness of any law or policy and regulation here is, the deterrent effect that it might have. And so one of the things that really goes into thinking about what kind of compliance program to put in place, how much risk to take around consumer data, what the products are going to look like, certainly informed by what the consequence of having a violation is going to be. And I think we have to be mindful of that, because really at the end of the day, what I think what we all want as consumers and probably as compliance lawyers is for there not to be a problem, for things to go well, for consumers to have the ability to use great technology and to avail themselves of all of the potential of that while also having their privacy protected and not ending up in the ex post enforcement world where there has been a problem.
So, I mean, I do feel, though, that as Noah has already alluded to, the elephant in the room, if there's an elephant in the room, nice thing about Teams or Zoom is that there may be an elephant in the room, but you can't see him because he doesn't have his video on or whatever. But if there's an elephant in the room, it is going to be this idea of private causes of action being a possibility, right? So I think, I mean, at least I'm speaking for myself, absolutely no one else. Just to say that it seems to me that I've heard reflected a certain consensus around the FTC having a role, the states having a role, right? And then, but there are other players. For example, there are individuals, there's class actions, there's community organizers or other kinds of nonprofits that might vindicate interest on the part of consumers, right? So I do want to ask a question and go around and just say, what are your views about a private cause of action? Is there a way to do that is going to be palatable? Is it absolutely needed? It's something that I've suggested, I know in my conversations with people, but what do folks think about specifically that private cause of action as a possibility? Terrell, if I could start with you, I would. May I?
Oh, gosh, thanks, Ryan.
You can pass. This is not my sports class where you're rated for your
for myself and not any organization, client, or anything else. I mean, look, I think you're right. It is the elephant in the room. This is why when I was thinking about zones of agreement and compromise here, I called out some of the other ideas that have been on the table, including, and I didn't mention them, potentially limiting attorney fees, creating organizations that can advocate on behalf of individuals, creating safe harbors, thinking about exactly which sort of rights and violations might attach to an individual cause of action as ways to potentially provide that right, which I think is an important right, while also addressing the issue that I think Lauren articulated so clearly in her comments about the sort of scope and breadth of potential liability that will bring if it's included in the legislation. So those are my 2 cents, and you're welcome, panelists, for taking that one.
Taking the first one, yeah. Thank you, Tara. We all owe you. Who else wants to jump in, please? Noah, please.
Sure. So I agree with a lot of what Terrell said. I mean, my fundamental view is that this is a bad idea, at least now, meaning we think about a private right of action as an additional deterrent, a mechanism to do what law enforcement cannot. And when you're dealing with privacy legislation, number one, you're dealing in an expanding area of the economy. You're dealing with an area with a lot of innovation. And so whatever it is that we are going to prescribe, we're going to chill that behavior and some amount of behavior in and around that. If we don't know what the consequences are going to be, starting with greater penalties, I think is the wrong way to do it. To me, once you see under deterrence, then it's the time to have that conversation. But the most important thing to remember with a private right of action is it's not going to be the worst harms that drive things. The driver of enforcement, once you introduce a private right of action, becomes the economics of lawyering. And you see the opportunity for strike suit behavior. And we saw this in securities. We see it in TCPA. I mean, all over, we create these private rights. And what you end up doing is a lot more than just deterrence. And one concern is that you chill a lot of good behavior. Another concern that I have is the economics that you create and the political economy that you create of people with a vested monetary interest in the status quo once these rights are created makes it really hard to course correct the law, the underlying rights. So if you get it wrong, you're sort of stuck. So that's why I think we need to start without a private right of action.
Got it. I think I saw Julia's hand, and then I see Lawrence too. So Julia, please.
Sure. So, I do not view any of the redress proposals that we've been talking about as being binary. Either you have a private right of action or you don't. Either you have enforcement or you don't. Really, what we've been talking about all along is looking at the different elements that one can build into enforcement, into individual redress for actual individuals, into things like rulemaking and guidances and things like that. When it comes to a private right of action, I think what most people mean, Noah, I think what you mean is what we sometimes call a full-blown private right of action with actual damages, punitive damages, and attorney's fees, kind of the full suite of remedies that go along with a private right of action in many circumstances. What I worry about is something I articulated before. If the substantive provisions of the law are strong, and I think at this point in time, not only is there bipartisan consensus that they should be strong, but also California has just adopted a new set of rules to go on top of the California Consumer Privacy Act. This is now the California Privacy Rights Enforcement Act, which adds an additional layer of substantive provisions. It's very hard to imagine a federal law going below the California standards. And so what we're talking about is something that's going to be a very strong law. And in that instance, I think it would be better for the ecosystem, better for consumers, better for everyone if we iterate around this issue. Perhaps we start out with giving individuals the ability, saying that companies have to have an internal redress mechanism, an internal mechanism, giving consumers the ability to go to state attorneys general or a new federal program that will mediate their complaints, perhaps giving them the ability to go to court if their request for relief in an injunctive fashion is not provided. So giving them injunctive relief. The full-blown private right of action, what I worry about is you'll have lots of companies that will suddenly be facing full-blown cases in courts with judges who have not been acclimated to these laws. This will all be new to judges as well. And you'll have a lot of companies that won't know what to do. You'll have a lot of individuals that won't know what to do, and you'll have a lot of judges that will be befuddled. I think much better to sort of take this a little bit slower, let the ecosystem get used to it, giving individuals absolutely some kind of redress, and then let's see how it goes. Because if we get it wrong, we could really do some damage to effective, robust use of data that actually solves problems, but does it in a respectful way. That's the sweet spot we want to hit. And that's why I think we need to carefully think about all the different items that are on our menu for dealing with redress.
Okay, so this has gone really fast. I know, so we're closing out on time. So I'm going to go to Lauren because I know she wants to contribute to this question. Then I have a rapid fire question, everybody, and then I'll let you get on with your afternoon with my big thanks. So Lauren, you wanted to weigh in first, and then I'll.
So I am in favor of a private right of action. I think it's important, and I think the important mistake that some people make is that this is a stopgap. This is something that is only there because we expect public resources to be underfunded. So we have them step in, private attorneys general. I don't think that's the case. I think there are two unique things that having a private cause of action does. And that's not to say the concerns of my colleagues here are unfounded. I think there could be limits to this private cause of action, like maybe limit the dollar value that can come out of such a case, or maybe require have some type of safe harbor, have a procedure that private cause of action takers have to take. I do, however, think it's important and necessary